Yes, Mr. Fitzgerald.
Yes, my lord. I hope that the board received our very short summary of our legal submissions over the lunch break, and that helps to clarify.
We did. Thank you very much.
It just seemed that the Hickey dicta encapsulated the test under ground one most helpfully. But so can I then answer the two questions that were posed? First, my Lady Justice McKerr asked me to deal with the chronology. Can I do the best I can? The case started on the 19th of September, and there was a question whether Grandison would turn up or not, but it was hoped he would. He didn't turn up on the 19th of September, although there were occasions when people said that he'd been seen in the court building. A subpoena was then issued at our request, and I think the police were asked to go and find him. It was then adjourned until the 26th of September for Grandison to attend. On the 26th of September, he didn't appear, so we called the evidence over Maharaj, Sean Paris, the Ramdeen, Gerald Ramdeen, and also we called St. Clair, who identified the voice and explained the circumstances in which she'd contacted Grandison. We then proceeded to start our closing submissions on the 27th of September. And you can find that, I think, at page 1387. The prosecution then asked for time before they gave their closing submissions. And they were given until the 3rd of October. So on the 3rd of October, it was scheduled for the prosecution to give their closing submissions. On the 3rd of October, the prosecution came with a notice of intention to call rebuttal evidence, which was served on us that morning. And you can see volume 4, page 1434, they got a fairly dusty response from the court, where court, so page 1434, the prosecution having made their application to call rebuttal evidence at page 1429, basically the prosecution said, we still say it's all hearsay, please chuck it all out. And then when the court said, well, we're going to look at it all, Justice of Appeal York Sue Hon says at the top of page 1434, Mr. Synonym, we all knew from the moment that the matter begun that the evidence was by way of statutory declaration there were difficulties. Even from the time the cause of this hearing, we knew that there were difficulties in getting Junior Grandison here. Why is it at this last minute, when we are at the state of closing submissions, you have now come to ask us about rebuttal evidence, if I may call it that, and make such a big hullabaloo about Grandison not appearing? We all know that he isn't here. We have to work with with what we have. And so that was that. And then we objected to them. We didn't know what their rebuttal evidence was at that stage, but we objected to them calling it. And at that stage, you can see at page 1436 that we anticipated that they should have interviewed Grandison in 2014. We didn't know that there were statements taken then when the matter was referred back. And we thought that it would turn out that these were statements taken very recently. In fact, as we know, they were taken in 2011 and 2013. We didn't get the rebuttal evidence until the 30th of October, when it was provided. And, for example, Ned's statement was filed on the 30th of October. The hearing then resumed, because the case had been adjourned, and on the 6th of November, when the prosecution called their witnesses, Ned and Frederick, and Father Ventor, and we cross-examined. And then, although we said that Father Ventor, in fact, supported our case and should have been disclosed to us as evidence of an exculpatory nature right at the start. And then the prosecution made their closing on the 7th of November. But you'll see that since Maharaj was called on the 26th of September, none of the rebuttal evidence was put to him. In other words, none of the allegations about phoning and bullying and all that, which I suggested were put to him by the prosecution. Now, the second question that I was asked was about the phone. The phone is dealt with in the SFI at 2123, page 2476. Just starting at page 2123 at 2475, Michael Maharaj communicated with Grandison in May 2017, by which time the appellant's case had been remitted to the Court of Appeal. Michael Maharaj said that he recorded those telephone conversations because he did not trust the police or the state. He was worried they might prevent Grandison from giving oral evidence. He also didn't trust Grandison. The calls were recorded on his blue Android cell phone. However, there were other conversations which he had using another phone, and he couldn't record on that phone. He said Grandison did not know he was being recorded, and we've shown you the passage which seems to bear that out. So his evidence you can find in chief about why he recorded him at 1322, where he says, because I didn't trust the police and I didn't trust him, and at page 1346 and 1351 in cross-examination. And I think that page 1346, you have, yes, so he deals with, at page 1346, he deals with why he recorded him. Were you able to record all of the, no, not the phone I had, that's at page 1346, line 34. And yes, this year I use a blue Android phone, so he could record it on that blue Android phone. And then he's cross-examined by Sinanan at page 1357 to 1358. But I don't think there's really that's the position. And in his affidavit, at pages 18 to 19, that's in volume 3. In his affidavit, at pages 18 to 19, paragraphs 18 to 19, and pages 982. Yes, he says at page 982 at the top, the telephone conversations were recorded on my Android phone. I sent the recordings of each telephone conversation to my son Dylan after each conversation took place. I sent the recordings via a mobile messaging application known as WhatsApp to my son Dylan, with instructions to send them to Krishanda Gulcharan so that she could send them to my attorneys at law. In the recordings, I can clearly recognize my own voice and that of Junior Grandison. Furthermore, I can confirm the transcripts of these recordings accurately reflect the conversations that we had. And then he describes the situation, and then he lists them. And yes, the tape 19 was disclosed at a later stage. That was the August one. The August one. Yes, so that's the position. Sorry, I'm sorry, my lord, sir.
Mr. Fitzgerald, just while we're sorting out the chronology to get it clear, can I check what the position was in relation to the statutory declaration, which I think was 2011, and why there was then the long gap before we have the further telephone conversations? How did the statutory declaration come to light? What use was made of it in 2011?
Okay, my lord, what happened was the statutory declaration was part of a petition. Well, in the light of the statutory declaration, there was a petition to the President to refer back, like the Home Secretary in England has the power to refer back to the Court of Appeal. And he then, so the President then had an investigation, but of course we didn't know what about that. Unlike in England, we weren't shown what the investigation revealed. But as a result, he referred the case back to the Court of Appeal in 2014. And then there were various...
Sorry, can I just be clear then? So was the statutory declaration made available to your clients sort of more or less straight away, and they then petitioned the President? Is that what happened?
Yes, yeah, whether it was more or less, yes, it was. Yes, and then they petitioned the President, my Lord, your Lordship's absolutely right. They petitioned the President refers it back to the Court of Appeal in 2014. There was a lot of delay because the defence team were asking for more disclosure, understandably, as it's turned out. But then in the end, it was decided just to go ahead. And in 2017, the case was listed for September, and you can see that really what appears to have happened is that Michael Maharaj resumed contact with Grandison as the appeal was coming up through the means of St. Clair, Gillian St. Clair, who met him, and then she met Grandison, and she then asked if the number could be disclosed. So
Yes,
that's the situation. My Lord, that being said, can I just move straight to the points of law, which we've set out? You have our detailed submissions on ground one in the case, and I can just indicate that those detailed submissions are set out in the case from page 2518 onwards. And can I just summarize? What we're saying there is the Court of Appeal should have found that the evidence was admissible, capable of belief, and that it undermined the conviction, and capable of belief in the sense that it was genuine. It was potentially genuine. And that's what we've set out in the summary of the points of law. But the alternative was you simply say, look at all the different things that at different times this man Grandison has said and done, and in the light of all that is now known, conclude that he was an unreliable witness. And that is the approach that seems to have been taken in Hickey. So if I can just, so the first part, the head of ground, for purposes of grounds 2 and 3, if I can take you to that short note, which I hope the court has now. For the purpose of grounds 2 and 3, the appellants submit the evidence of Grandison's retractions are capable of belief if they are capable of being construed as admissions that Grandison lied at trial, and they are reasonably capable of being construed as genuine admissions. The Court of Appeal either failed to apply that test or applied it in a wholly unreasonable way. We'd probably say both. Applying that test to the statutory declaration, the appellants submit that it is obviously capable of belief that Grandison admitted fabrication in his statutory declaration. It's obviously capable of belief that this was a genuine admission. And that is particularly so, given that the genuineness of those admissions in the statutory declaration is further supported by what he voluntarily says in the recorded telephone conversations. So it's capable of belief, and then we've dealt with that in relation to ground 2 at pages 2530 following. I think I took the court briefly to that, but they don't have to find that they accept it. As was recognised in McKenney, it may be that the Court of Appeal can't decide who's telling the truth, but they can decide that this is evidence which should be admitted and which undermines the safety of the conviction, because applying the Pendleton rule of thumb test, you can say, well, what is it likely that a jury would have concluded? if they saw that. And we've set out the Pendleton test at page 2536, 12.1. The Court of Appeal is not and should never become the primary decision maker. In other words, and it's exemplified in the Parks case, which is set out at 11.5, page 2533. The court can say, this is capable of belief, it is capable of being believed by a jury. We will admit it, and we will conclude that had this evidence been available to the jury, they might have reached a different verdict. Therefore, we will conclude that the verdict is unsafe. That, for example, was done in the case of Barry George, where the evidence was admitted, and they applied the test of, well, if this evidence had been available, what would be, it was applied in the case of McKenney in relation to admissions. He'd written a whole load of letters to a pen pal girlfriend in which he admitted other crimes and in which he admitted that he lied. And they admitted that evidence. And we've cited that in our case. So we've cited that at 9.3. So if we go back to paragraph 3, turning to the recorded conversations themselves, the appellants submit. Firstly, it is plainly capable of belief that the statements contained in the recorded telephone conversations were made by Grandison. Secondly, it's capable of belief that they amount to admissions of fabricating his trial evidence and a further admission of responsibility for the murder of Pigeon. Finally, it is capable of belief that these admissions of fabrication and of the guilt are true and genuine. So the court doesn't have to decide if it is true and genuine, but it does have to accept that it's capable of belief. And we would submit that if the court had to decide, are they true and genuine, it's more likely that they're true and genuine than not. But that's not, you don't have to go that far. The test for capability of belief is that set out, it's set out in the case at 11.5, page 2533, but also in our reply at 3866, namely whether it is evidence open to a jury to believe. And that's the test derived from Parks. And as is clear from Lord Bingham in Pendleton, the threshold is not necessarily a high one, since the purpose is to exclude obvious nonsense. I mean, that's the example he gives. I'm not saying that it's obvious nonsense, but he makes the point. And then he stresses that the really important thing is, once you've admitted it, what effect it has on the safeness of the conviction.
Mr. Fitzgerald, there's a question from my lady.
I'm so sorry, my lady, yes.
Mr. Fitzgerald, quite clearly the authorities contemplate three different situations. Evidence that is obviously not capable of belief. Evidence that is obviously capable of belief. And then the third category, where usually they hear evidence de bene esse. So on the basis of your arguments, what's the court's role then in determining that the evidence is obviously not capable of belief?
Well, my lady, what I would respectfully submit is that it's a limited one, and Lord Bingham gives the example of it's obvious nonsense. But my lady, typically,
don't the judge, forgive me, don't the Court of Appeal then make an assessment and say this is obvious nonsense? It's been put forward, obviously with a view to being accepted as credible, but the Court of Appeal have said, well, this is obvious nonsense, so they've made an assessment of that fact.
What I accept, my lady, is that the Court of Appeal has a threshold role in determining that. I accept your ladyship's point. Of course, the Sales test, which formulated that tripartite test, was contemplating particularly, as it were, witness evidence. So the witness says something and it's obviously nonsense, you don't even hear it. Then it's plainly capable of belief. We'd submit that this is plainly capable of belief. And then there's the in-between where you hear it de bene esse and you determine. Of course, in this case, you couldn't hear Grandison de bene esse, so all you could only make an assessment of the recordings.
Yes, I appreciate that. What I'm trying to understand from your argument is that you're saying that the court have got a role, but I'm trying to push you on the fact that if someone submits evidence, they obviously would not do so if it is patently ridiculous nonsense. So the Court of Appeal make that assessment.
I accept that, my lady. For example, I accept sometimes you submit evidence and then the prosecution put in evidence in rebuttal which shows that it's just impossible to be true. The person wasn't in their cell, for example, at the time. And then they say it's patently incapable of belief. And I accept that is, that, you know, that, I know your ladyship will know better than me, but that happens the whole time. The Court of Appeal just say, this is patently incapable of belief. So I'm not saying there's no threshold exercise, but I am saying that one should not confuse that threshold exercise with a full-on, who do we believe? And that's the point that Parks makes. Is it open to a jury to believe? And they say in Parks, they actually say it. I think it's 1392, but it's the 92 page. They say we're not going to decide whether this is true or not, but we couldn't say, having heard it, that a jury couldn't believe it. And if you take that here, and you ask yourself, or the court asks itself, if a jury heard that the admissions about the murder of Pigeon, would they accept that that was a genuine admission? Well, obviously it's likely they would, but they might well believe it. And then so you'd admit it. It's capable of belief. Would the jury believe that when he says, I can't tote it, it's been on my conscience, and lying was as easy as shooting a gun at someone and killing them, lying against you and getting you hanged was as easy? Would they believe that that was capable of being a genuine admission that he lied at trial? Yes. The jury could well believe that. Indeed, we would say that that's the obvious interpretation. So you admit it. And then you ask yourself, well, what impact does it have on the safeness of the conviction? And I admit that there, the test, you can look at it in the round. And sometimes where there's sorry, yes, my lady.
Carry on with the answer to the question, and then I'd like to answer.
Well, sometimes, sometimes the court says, well, we admit this new evidence, but given the overwhelming nature of the evidence at the trial, we don't think it has more than a peripheral impact or a limited impact, and we're still satisfied of the basic reliability. But here there's only Grandison, and he starts with, as it were, -3 points. Well, -10 points, we say, because he's an accomplice, he's a criminal, he's giving evidence of cell confessions, he changes his story, etc. Now, it's not good enough to then to say, well, the jury was satisfied, because we don't know what the jury would have done if they'd heard the evidence that they haven't heard. Sorry, my lady.
Yes, you've shown us Mr. Maharaj's affidavit, so you were clearly intending to introduce the recordings into evidence, even though at that stage you expected Mr. Grandison to arrive and give evidence in the witness box. But when he didn't arrive, those phone calls then take on a different aspect, don't they? Because they then have to become admissible as hearsay evidence of what he would have said had he been in the box, but that he hasn't in fact said. So could you say something a little bit about how the test as to the credibility of the phone calls might have changed, given that they were then serving a different purpose from the purpose that you had expected them to be serving?
Yes. Well, my lady, firstly, they were evidence of the fact that the statements were made. And that's the point that is made by Lord Wolfe in the case of McKenney, in respect of the state. So Childs, who was the key witness in McKenney, had made he'd written a number of letters saying that he lied, and those letters saying that he lied were admitted. We've got it at 9.3, Court of English at page 2521. They say they couldn't decide whether truth lay, but they admitted the statements in correspondence written by Childs, the recanting which Childs was not to know would feature in possible appeals. So, and Lord Wolfe said, well, they're evidence of the fact that they were made. So they're admitted on that. Now, my learned friend makes the point, well, there was also psychiatric evidence that Childs was unreliable, but that was based on those statements. So, my lady, first of all, the statements become admissible as impeachment material, as is said in the Canadian and Australian cases. You could put this to the witness and say, do you still deny killing Pigeon? Yes. Well, look at your admission. Do you still maintain your evidence? Well, look at what you said about fabricating it in all those passages we've cited at 1.3. So it's admissible for the fact that it was said. It would be admissible as impeachment material, and the same question arises: is it capable of belief that it's that the stuff you would be putting would be true? And that's the only reason why in the reply we've said that it's when you're dealing with this kind of fact that a retraction statement has been made, using the language of capable of belief is slightly awkward. It may be better to use the language of evidentially significant. But my lady, we would what we would say is it's capable of belief that he said it, and therefore it's admissible as impeachment material. You could put it to him. Did you say this? And he'd either deny it or not. And if he denied it, it would become admissible evidence to prove an inconsistent statement. So it's admissible, and it's admissible as said in Schneider, and as said in the Australian case of White. It's admissible as impeachment material, and that's so my lady. Sorry, I hope that helps. My lord, yes, my Lord Sales.
Yes, I mean, just the way you're putting it there strikes me as a bit unrealistic. There's no prospect at the time when the Court of Appeal is holding its hearing that Mr. Goodison is in fact going to be available for some future retrial or anything like that. I think one of the justices says he's not here as a witness. We've got to do what we can with the material available to us. So why isn't the right way to look at this as he made a statement, his statutory declaration, but isn't prepared to come to court to back it up?
Because, my lord, he's a prosecution witness, and the prosecution actually could have got him there themselves. In other words, it's as if I mean, what happened in the Hickey case was that the witness was called by the court itself, and both sides cross-examined. Sinton was called by the court itself. Equally, in the so that's in the Hickey case. In other cases,
I'm sorry to interrupt. I mean, isn't the position at the time of this Court of Appeal hearing that he's a witness on whom you wish to rely? You wish to rely upon his evidence, new evidence in his statutory declaration, and indeed it's you've told us who sought to bring him before the court by issuing a subpoena.
Yes. So that. Yes. Sorry.
Well, I was just slightly confused as to why, at this point, we look at him as a conventional prosecution witness when he's a witness you're trying to bring before the court, whose evidence you want to be introduced as fresh evidence.
Well, my lord, I think it's if I can respectfully say so, it's a little bit more complicated than that, because it's a fact that this witness has made a number of retractions to Father Ventor, to Mr. Ramdeen in his statutory declaration, and that he has made statements in the transcripts. So we are entitled to prove that the prosecution witness has made a number of inconsistent statements. That evidence was admitted without calling Childs in the McKenney case. Lord Wolfe admitted the evidence of the fact that he'd written letters making various statements as evidence of the fact that those statements were made. And likewise, so that's the McKenney case. Likewise, the Canadian court in Snyder said that a recantation can have impeachment value even if it is not to be believed. Indeed, a demonstrably false recantation can have impeachment value. In other words, you can say, well, it's admissible as evidence of the fact that that statement was made. It's admissible as evidence that this person has a motive to lie. You admit it because it at least proves that. And then you ask yourself, in the light of all that is now known, is the verdict still safe? And in a sense, the prosecution were relying on him because they were relying on his repudiation. They were saying, believe his repudiation, not his recantation. So it's just as much an onus on them to call him.
But I thought the whole point of that was to rebut what you were seeking to put in evidence.
Yes, but my lord, could I just try and finish that, my lady, first, and then? So,
Yes, cool.
my lord, what I respectfully submit is this: the evidence is admissible as evidence of the fact that he has made these series of convincing statements. It's definitely admissible for that purpose. Then the court says, well, what impeachment value would that have if the jury were aware of it? And the answer is quite considerable. Very often you don't have to. I mean, supposing the witness is dead, but has made a confession before it. Or as in the Childs case, the prosecution say in the McKenney case, they said, we're not calling Childs for these statements to be put to him. You make your submissions on the basis of the evidence. We don't believe a word he says. So, my lord, I say that we get in through the door by reference to the fact that these statements are admissible as evidence that he has made these detailed confessions. Then the question is, if we're going on ground one, what is the effect of these multiple admissions on the safeness of the verdict, on the stability of the verdict? But I do submit that if you go down the path that the Court of Appeal did, which is deciding whether those statements were capable of belief, their reasoning that they weren't capable of belief was wholly defective. My lord, I don't know whether I've quite answered your question, but I do accept.
I think my question was perhaps directed more to the second part of what you were talking about, assessing the impact.
Yes.
Why is the Court of Appeal not permitted to make an assessment that here's someone that in 2011 made a statutory declaration, but he plainly is not prepared to come to court himself as a witness to back up or speak to that statutory declaration, leaving them with the difficult task of assessing just written statements, of which there are a number, without having him on hand to give them assistance?
Well, my lord, my first respectful answer would be that it's not just written. It's viva voce. It's his own voice.
Right.
You can actually, no, but that does make a massive difference. I mean,
Right. Okay. Okay. Mr. Fitzgerald, I accept your point on that, but it remains the case that Mr. Goodson is not there as a witness to back up or explain what he meant, even in the telephone conversations.
Well, nor was that the case in McKenney, where the witness Charles was not called in that case.
Certainly, but my question really is, isn't it legitimate for the Court of Appeal to take into account the way in which this witness has not been prepared to come to court, even though he could have done, in assessing the significance of written or recorded statement, incomplete recorded statements by him?
Well, my lord, can I just, I accept it's a relevant factor, but what I would submit is that an equally relevant factor is why. And we know, because it was given great publicity on the first day of the appeal, that Grandison was fully aware of the transcripts and what was said in the transcripts, because we had to discuss them in open court. The reason why Grandison didn't turn up is most likely because he would then have been faced with, why did you perjure yourself? What about this admission to murder of Pigeon? And it may be a factor that he didn't turn up, but it's not a factor that counts against the appellants. It's a neutral factor, because the obvious reason why he didn't turn up was he'd been playing both sides. He would, if he did turn up, he would render himself triable for perjury, one way or the other, either in his statutory declaration or in his evidence at trial, and he would have to confront the fact, because it had been given publicity, that he'd admitted murdering Pigeon. And so that's the obvious explanation of why he didn't, and we made that point. That's why he hasn't turned up. The reason why he hadn't come actually was neutral. It didn't assist the prosecution, didn't assist the defense. The defense would have wished him to turn up, but what we were asking the court to do was which is what was done in the Hickey case, was for the court itself to call him, so that both sides could cross-examine him.
Yes,
in other words, this idea that it's that this is our case, either our guy comes good, Grandison comes good, or we lose the game, is not, in our respectful submission, the right approach. The right approach is, there is this witness on who 9 people were sentenced to death and nearly hanged. He has subsequently said he perjured himself. He lied about murders which he did commit. He's made those statements. What is the effect of all that on the safeness of the conviction? And one can't just say, well, it's your funeral if he doesn't turn up, because the reason he doesn't turn up is he's an unreliable, lying, murdering, perjuring witness. That's why he didn't turn up. So why should we suffer because of that? That's, as it were, the game theory of criminal justice, not the justice theory, as it were. And if you look at how Lord Wolfe approaches it in McKenney, he says the fact that Childs has made these confessions is admissible. Just trying to give you the I think it's in volume 1, McKenney, volume 2, volume 2 tab 16. Yes, and
3258.
I'm very grateful, Malia, 3258, and then the key bit is he says, paragraph 62, page 3272. The retractions were made by Mr. Childs to the police and to other witnesses. They are contained in statements and in correspondence. While, as Miss Kern submits, the statements can usually properly be described as hearsay, as to the truth of the facts stated in them, usually, that is, the statements are undoubtedly admissible as to the fact they were made. And then he goes on, the statements detract further from the credibility of Childs and confirm the medical evidence that he is a pathological liar. Now, there was strong argument about the statements detract further from the credibility of Childs. Now, it's not just that, but also an admission of your motive made to another witness is admissible as an exception to the hearsay rule. And that's Tomlin's case, which you have in the extra bundle. So in other words, if you say to someone, the reason I gave this evidence at trial was because I had it in for Damien Ramaya, that evidence is admissible in itself as evidence that the chief prosecution witness had a motive to lie, which the defence didn't know about. So it's admissible as evidence of motive. And in the Tomlin's case, which is in the supplementary bundle, Lord Justice Glidewell makes that point about, well, the evidence of yes, it's in the supplementary bundle at page 44. What she said to her sister were totally inconsistent.
Fitzgerald, Mr. Fitzgerald, we're going to have to keep an eye on the clock, I'm afraid.
Okay.
We're at a point where you're going to have to draw your conclusions to a close, but I think my Lady Justice McCare has a question.
Okay, thank you.
I did. I think some of it's already been answered, but just to be clear, Mr. Fitzgerald, at the time that the Court of Appeal started to hear your submissions on the entry of the new evidence, there was every expectation that Goodison would attend.
My lady, the position was we did not know whether or not Grandison would turn up to give evidence on the first day of the appeal.
Right.
Sorry.
I was going to say there's indication in the transcript that there was late provision of the final audio tape. It was said to be provided the day before or the morning of the court hearing.
Yes, my lady, that's right.
And going from my Lady Rose's point, at that stage, it had already been determined to produce all of the audio tapes.
Yes, my lady, yes.
So if Goodison had come along and stuck to his statutory declaration and given evidence that that statutory declaration was true, what use would you have made of the audio tapes?
Well, I'm not sure we would have made use of it, but what we thought was that it would be better to disclose everything, unlike the prosecution, because if we had sprung it on the other side at the last minute. But your ladyship's entirely correct. If he'd come and said what he'd said in the transcripts and in the statutory declaration, there would have been no need for it, because he would have said, I lied, and that so if Grandison had attended and said what he said in his statutory declaration, we wouldn't have needed them. If he'd attended and said part of what he said in the statutory, but the other part, we might have wished to cross-examine him. But we had said to the court right at the start, because we don't know, as it were, what he's going to say, we'd ask the court to call him itself so that both sides can cross-examine him.
Yes, and finally this, you say that he would have known what was in the transcripts, but why would he have known what was in the transcripts?
Because, my lady, on the first day of the hearing, as part of a submission that the evidence was admissible, I read out to the court in open court great chunks of the transcripts. They received publicity, and he obviously, if he was in Trinidad, the suggestions that he'd done a flit to Venezuela at some stage or whatever, but if he was in Trinidad, would have read that. He would have known. I mean, on any view, he was going to face trial for perjury by one side or the other, or allegations of perjury by one side or the other. So that he couldn't have avoided whatever he did, although we didn't know about the retraction statements. But once there had been the publicity about there are these dramatic tapes which reveal what he said, then obviously he would have been aware that he would have some answering to do. And my lady, we didn't, the truth is, we didn't know for sure whether he would turn up or not. We hoped he would turn up. We didn't know. There were various claims of sightings of him coming into the court, I think on the 26th, that he was going to be there. But as Mr. Grandison said, he always feared that he wouldn't turn up, because you've seen in one of the tapes he's saying, "Do you really need me, boy?" And he says, "Yes, I really do."
Right.
Yeah, right. Thank you. Thank you.
Mr. Fitzgerald, need to draw your submissions to a close now, please.
Well, okay. Well, my lords and my ladies, I respectfully rely on the ground one as set out in the case, and as set out in the alternative formulation in the short note. And we commend the test, the alternative test, once all that has become known through Grandison's since the trial is taken into account. Do those developments undermine the reliability of his evidence? We say they do. We apply the test. This is at para 9 of our short note. We apply the test in Hickey number 1, which is also applied in Hickey number 2. You have in the supplementary bundle at pages 16 to 19 of that. We apply the test in McKenney, analysed in the case. We apply the test of, that's to say, of impeachment material in Schneider and White. And we say on all those grounds, the evidence would be admissible. We then say in relation to ground 2, that the court, instead of asking itself the question if capable of belief, sought to decide which side it believed. And finally, we say that actually it was an irrational decision for the court to conclude that the evidence was not capable of belief. And in support of that submission, we rely on all that we've set out in notes 1 and 2, and we also rely on Appendix 2. We say and the summary that's set out in the case at 1.3. It would be possible to say, if it was a straight choice between the statutory declaration and what was described as the repudiation statement to Ned, it would be possible to say, well, they balance each other out, and we're not prepared to conclude that the statutory declaration is capable of belief. It would be possible to say. But once you've got the audio recordings, we say that those make it impossible to say the statutory declaration is incapable of belief. And it certainly makes it impossible to say that the admissible utterances, which are, as a matter of fact, made in the audio recordings, are not admissible. They're admissible as evidence of the fact they were said. They're admissible as evidence of malice and motivation. And we would say that the court can have regard to all this material and conclude that the verdict, the conviction, is unsafe.
Thank you. Thank you, Mr. Fitzgerald. Mr. Poole.
My lords, my ladies, I'm grateful. My lords, my ladies, the parties have committed an awful lot of material to writing, and obviously I adopt and rely on the respondent's written case and the 2 appendices to that case. The first of those appendices dealing specifically with the audio recordings and the transcripts, and we say that repays reading, I hope, in the sense that it is a complete answer to the various points that my learned friend has been making this morning about the transcripts and the inferences that can and cannot be drawn from them, and we say it is supportive of the Court of Appeal's reasoning. And the second appendix is a summary of the retraction statement that was given to Officer Ned. Now, what I propose to do is follow the structure of the respondent's written case. So start by saying something about junior grandison, then the relevant legal principles, then the Court of Appeal judgment, broken down into the three main aspects of the fresh evidence, and then deal with each of the four grounds. I would hope to have got to the end of, if you like, the third section, the Court of Appeal judgment, by close of play today, and then we'll be just about there for the timings tomorrow. If I may start with giving the board what we say are short answers to the four grounds. We've provided these by way of an overview in our written case. It's paragraph 7 of our written case, which is page 2611 of the electronic bundle. As to the appellant's first ground, we submit that there is simply nothing in the complaint that the Court of Appeal erred in law or principle in the way in which it approached the fresh evidence. In this case, the appellants relied on Grandison's recantation as substantive evidence and also as evidence for its impeachment value. Now, we say even if they had relied solely on it for its impeachment value, the Court of Appeal still had to satisfy itself that it was in the interests of justice to receive it. And a necessary part of that assessment, we say, is to determine whether it was the product of collaboration between the appellants and Grandison or unacceptably tainted by the appellants, and then to go on to consider the effect, if there was such taint or influence, on its capacity for belief. We say that is precisely what the Court of Appeal did. It carried out a rigorous assessment, and I use those words as those are, when we look at some of the authorities, the test is set out in slightly different language, but it is the rigour of the assessment that I emphasise, given that this is recantation evidence and it's easily fabricated. And again, we'll look at some authorities that make good that point. So having carried out that assessment, we say that the Court of Appeal drew conclusions that it was entitled to, and there's no basis for interfering with those conclusions. As to the second ground, we submit that the Court of Appeal applied the correct threshold of credibility that fresh evidence must meet. And we say that when one looks at the Court of Appeal judgment, the analysis of the fresh evidence is bookended by the Court of Appeal setting out the test, we say correctly, at paragraph 102 of the judgment, which is page 1129, and it ends at paragraph 175, 1157. And we say that whereas here the fresh evidence consists of recantation and retraction, the Court of Appeal properly explored the explanations offered for that recantation and the extent it was supported by other evidence. As to the third ground, we submit that this ground ought to fail if the appellants have failed to persuade the board, as I submit they should, that there has been no error of approach or principle in the Court of Appeal's analysis of the fresh evidence. We say that this ground is no more than the appellants urging on the board their own interpretation of the audio recordings and effectively rerunning the arguments that were rejected by the Court of Appeal, who listened to the audio recordings, read the transcripts and heard oral evidence from a number of witnesses, importantly though on this point, Mr. Maharaj, who was taken through by Mr. Fitzgerald the audio recordings in examination in chief and asked to comment at various passages of them. We say properly analysed, the transcripts of the call and the audio recordings themselves provide cogent evidence of coaching, prompting and influencing, as the Court of Appeal found. And we say that, lest the board obviously doesn't need reminding of this, but the board is not sitting as a second court of criminal appeal. And we say that the local Court of Appeal was in a better position than this board to make findings as to credibility and inferences that can properly be drawn from those recordings. And as to ground 4, we say the Court of Appeal was right to find that Grandison's trial evidence was supported, and I emphasise that word, not corroborated, but supported by 2 other witnesses, and those witnesses were Amoroso and Sumai. So before addressing the legal principles, I just want to say something about Grandison, because much was said at the start of Millen Friends' submissions about Grandison being a thoroughly discredited witness and someone that we can have no reliance, place no reliance upon. And of course, it's the appellant's case that the entirety of his trial evidence was a fabrication. That's the logic of their position. Now, Grandison gave 2 very detailed statements prior to trial. The board has these at, the first statement was made on the 7th of July, 98. That's at pages 42 to 51. And if the board is going to look at that, just to note that the typed version that's at 42 to 51 is unfortunately missing some pages. And the pages are in fact in what's called the supplemental record. But if I could just give the board the page numbers, it's 2194 and 2196 are the missing pages, but unfortunately they haven't been inserted in the right places. And the second statement that he made was on the 16th of July, 98, and that's at 49 to 50. He was then subject to extensive cross-examination at the first preliminary inquiry that took place on the 21st of July, 98. And you've got that at pages 14 to 37. And the magistrate found his evidence of that first preliminary inquiry to be, quote unquote, unshaken by cross-examination. And the reference there is at page 1550. So just pausing there, if Grandison's recantation is to be believed, and this is a point that the Court of Appeal make in their judgment, he's prepared an entirely made-up account, committed this to memory in 2 weeks, and then maintained that stance throughout the preliminary inquiry and under the scrutiny of 3 days of rigorous cross-examination at trial that I'll come on to in a moment. And as the Court of Appeal also note, all the while holding strong conscientious and religious objections to what he was doing. And that's one of the many reasons that the Court of Appeal found the recantation lacked credibility and was the product of coaching, prompting, and influence. Now, Grandison's trial evidence is perhaps most conveniently set out at paragraph 8 of the SFI, which is page 2456. We deal with it in our written case at paragraphs 10 to 12, page 2613. But the overarching submission is that his evidence was, as I say, thoroughly tested in cross-examination. He was cross-examined, and if I just give the board the references, 2nd of July 2001, cross-examination starts at 254, ends on 277. Then on the next day, 3rd of July, 280 to 432. And then the following day, 4th of July, 436 to 501. And the main lines of questioning are again conveniently set out at paragraph 8.9 of the SFI at page 2458. And just so the board has well in mind what he was cross-examined on, it included whether he had killed Ian George, who is referred to as Pigeon. And his evidence wasn't a blanket denial. He admitted playing a part in the killing. That's at page 332, lines 40 to 42. And he in fact said at page 451 that he would confess. He says, are you prepared in your changed state to confess to your involvement in that murder? And he answers, if it reached to that, yes, sir. It reached to that now is the question. Yes, but that will include Sinath Ramaya, Bobby Ramaya, and his mother. He was cross-examined on the number and severity of the offences with which he was charged, but those charges had been discontinued shortly before trial. He was cross-examined on the fact that he had not been charged with the present offence, despite being an accomplice. and he was cross-examined on various inconsistencies in his evidence. Now, in my submission, as a result of that cross-examination, the jury would have been left in absolutely no doubt what the defendants were saying, and they were saying that Grandison's evidence is entirely false. He's a criminal that can't be trusted, and he's only giving evidence against the appellants in order to curry favour with the prosecution, as he's got a number of outstanding criminal charges against him. And it was in fact put to Grandison in cross-examination that the deceased's brother, Panalal Boodram, had given him some inducement to give evidence against the appellants. We see that in the cross-examination at page 260, and the judge reminds the jury of that in the summing up at page 591. Now, that, of course, is a principal feature of his recantation, something the jury must have rejected when convicting the appellants. It was also put to him that he knew that Raj Kumar's evidence was unreliable, and that is why he needed to give evidence against the appellants. And we see that referred to in the summing up at page 592. As well as that rigorous cross-examination, the judge gave appropriate warnings, and I say in fairly extreme and strong terms. The board has the summing up starting at page 562. I can just draw specific attention to a few passages of that. At page 572, lines 23 to 30, the judge makes it clear to the jury that the two main planks of the prosecution case are Grandison and Amoroso. At 585, starting at line 38 and finishing at 587, line 30, and I say that is a passage that repays reading. The accomplice warning is given. The jury are reminded repeatedly that Grandison was in custody with matters pending, and the jury are told he had no immunity and that there was a very strong inducement for him to ingratiate himself with the prosecution because he, quote, he hasn't gotten anything yet. The judge then goes over Grandison's cross-examination in detail, starting at page 591 through to 597, 6 pages of summing up. The jury are reminded about the inconsistencies in his evidence. So all the points that Mr. Fitzgerald started this morning. So the fact that he had said that he had met Jake around at the end of July, when that was not possible based on prison records because he hadn't been released until the 31st of July. He was cross-examined on that. The fact he had told Vern Pierre he'd been given an inducement to testify against the appellants. The fact that he knew that Grandison's evidence was unreliable. That's why he needed to give evidence. These are all on pages 591 through to 592. The suggestion that he'd been promised his freedom in exchange for testifying against the appellants, and the suggestion that he didn't attend trial when he should have done, and would change his testimony. That's at 593, lines 1 to 22. We say, in light of all of that, so in light of the cross-examination, the summing up, it is difficult, if not impossible, to see how the points that the appellants are now making about Mr. Grandison's criminal record and bad character would have made any difference to the view that the jury took of his evidence. Now, there's been much made of the charges that he was subject to, and I think there's a list of those charges in the appellant's original petition to the board back in 1996, which is page 2344. Now, the respondent is not in a position to confirm with 100% accuracy all of the charges on that list, but we know from the evidence that he was subject to a number of charges, and the position is set out at paragraph 8.11 in the SFI at page 2459. So we know that the charge against him for Ian George Pigeon's murder had been discontinued on the 7th of June, so a couple of weeks before trial, and he'd been charged with the attempted murder of Courtney Reed, and that had been discontinued on the 15th of June. Now, he gave some evidence about that in re-examination, explaining that the state's main witness in the case couldn't be found. That was Courtney Reed. But the important point is that there was no immunity granted to Grandison. And as we say at paragraph 15 of our case, 2616, full disclosure was given to the defence of all of the advantages that had been extended to him, and all of it was dealt with extensively in cross-examination. and in the judge's summing up. So the jury were well aware of the position. And we do say, in the circumstances, it is pure speculation to suggest that Grandison must have known that if he gave evidence against the appellants, the states would not proceed against him for various charges. And we know that there were certain charges that still remained after the end of the trial. Now, just before I move off Grandison, I think my learned friend said he was a thoroughly discredited witness. And the example that was given was that he had given some evidence at his girlfriend's inquest that had been disbelieved. Well, there's no evidence of that. And in any event, the focus must be on his evidence at trial, which we say was clearly accepted by the jury, despite the challenges made in cross-examination and the robust warnings of the trial judge. If I can move then to the legal principles. Now, the legal framework for admitting fresh evidence is uncontroversial, and I think it's fair to say that both sides in their written cases cite authority for emphasis rather than to resolve any material issue of principle. It's only really when we come to considering the receipt of recantation evidence as fresh evidence that there is perhaps an issue of approach. But if I start with the general principles for receiving fresh evidence, because there's been no reference so far to Section 47 of the Supreme Court of Judicature Act, which is what power the Court of Appeal was exercising in this case. The board has that at 2737, and that provides that fresh evidence may be received if the court thinks it necessary or expedient in the interests of justice. And we refer at paragraph 17 of our written case to what Lord Carswell said about Section 47 in Pittman, which the board has at 3454. And the quote from Pittman is at paragraph 31, where Lord Carswell said, "The breadth and generality of this power do not remove the long accepted requirements of the law that fresh evidence should appear to be capable of belief and that a reasonable explanation be furnished for the failure to adduce it at trial." Now, as Lord Carswell says there, those factors are not conclusive. Submit, however, that if the court considers fresh evidence to be obviously unworthy of belief, the court would be extremely unlikely to admit it. It's difficult to see how it would be in the interest of justice to admit such evidence. And that point was made by Lord Hope in the Benedetto case. And the board has that at 2783. And the relevant passage is paragraph 66 to 68 of Benedetto, which is at 2808. And we do submit that what's said at Benedetto is particularly relevant to the present case. So what was said there is where fresh evidence appears on its face to be credible of being believed, but is challenged by the prosecution as being false or incomplete or misleading, then the court may find it convenient to defer a final decision until it's heard the witnesses. And obviously, this is the course that the Court of Appeal adopted, and that's the course that is regularly adopted, certainly in the Court of Appeal in this jurisdiction, following the guidance set down in the Queen and Sales case, which the Court of Appeal cite in their judgment, and the board have at 3658. It's the judgment of Lord Justice Rose at 3665 is the electronic bundle reference, where it sets out the three categories of evidence, and the Court of Appeal concluding in this case that Grandison's evidence fell into his third category. If I can now turn specifically to address recantation evidence, because it is a particular species of fresh evidence with, in my submission, its own principles. And we address those principles at paragraph 21 to 24 of our written case. And in my submission, there are 4 principles that can be drawn from the cases we cite in our written case, and also the cases that we refer to, and I'll take the board to when considering ground 1. And those four principles are these in my submission. First, recantation evidence should be subject to the strictest scrutiny, as it can be easily fabricated and or a result of manipulation. Second, we say recantation evidence can be admissible for two main purposes. As I've already said, it can be admissible as substantive evidence, i.e. in the present appeal, the appellants were not involved in the conspiracy to kill and murder, kidnap and murder the deceased. And it can also be relied on and admissible as impeachment evidence, namely that Grandison's trial testimony is inconsistent with what he said in his recantation. The third principle, we say, even if it is relied on for its impeachment value, it must still satisfy a minimum credibility threshold, i.e. it must be capable of belief. And when we look at some of the cases, particularly some of the Canadian cases, particularly Babinski, they refer to it as an important safeguard against fabricated evidence. And then the fourth principle is really a practical application. When assessing the credibility of recantation evidence, we say that the appeal court must scrutinise with particular care any explanation that's offered of the recantation and the extent to which that recantation is supported by either trial evidence or other evidence offered on appeal. And that is part of the process of determining whether it's the product of collaboration or taint, and then assessing the effect, if it is, on its capacity for belief. If I can just make good those four principles. So the first was risk of manipulation. We rely on, in particular, two Court of Appeal decisions from this jurisdiction. They're at paragraph 22 of our written case at 2618. And the board will have the references there. But the first is the case of Asif Patel and judgment of Lord Justice Leveson at paragraph 43, which is at 3406. And then the case of R.V.S. and judgment of Lord Justice Davis at paragraph 49, which is at 3781. The relevant passages are quoted in our written case, and I'm not proposing to turn up the authorities. There's also the case, as I referred to, of Babinski, which the court has at 3908. Now that's a decision of the Ontario Court of Appeal, and it's what the Court of Appeal say at paragraph 62 of that case, which is 3937. And I will come back to Babinski for a different proposition, but simply for this proposition, it is paragraph 62. Simple recantations, I read, are properly subject to strict scrutiny because they can be easily fabricated. The reasonably capable of belief test can be an important safeguard against admission of fabricated evidence. Second principle is the importance, we say, of credibility, whether it's relied on, the recantation is relied on the substantive evidence or for its impeachment value. And I say, again, Babinski is helpful in this regard. And just so the board wonder why both sides have referred to Canadian jurisprudence. The Canadian jurisprudence is helpful in my submission because the admission of fresh evidence on appeal is governed by now what is section 683(1)(d) of the Canadian Criminal Code. And we haven't got, although we can provide the board with that, but it is set out in one of the cases. It's set out in Palmer and the Queen, which is at 3371. And I just asked the board to, so cited there halfway down in the left-hand column, the reference to section 610 is the previous section that became 683, but without any material changes. And you'll see there, for the purposes of an appeal, D, receive the evidence if tendered of any witness, including the appellant who is competent but not compellable. Sorry, I missed out, as is always the way, the most important words, where it considers it is in the interest of justice. So it is the same test in my submission that the Court of Appeal are applying in Trinidad and Tobago. But albeit, what the Court of Appeal in Canada do is they assess the fresh evidence, and you see this from Babinski, from Palmer 3380, asking themselves 4 questions, namely, could it have been obtained with due diligence? Is it relevant? Is it credible in the sense of being capable of belief? And if believed, could reasonably, when taken with other evidence adduced at trial, be expected to have affected the result? And there are a number of cases, Babinski being one of them, where the Court of Appeal of Canada, Ontario, have considered specifically recantation evidence. And so if I can just ask the board to turn up Babinski, which is 3911. And we can take the facts from the summary that you see at 3911. In short, a witness recanted his trial testimony incriminating the appellant. The witness then resiled from that recantation, but by the time the appeal was heard, it was clear that that recantation was false, and that the recanting witness had fabricated evidence, in fact, in an effort to implicate the appellant in the false recantation. And relying on the case of Palmer, which I've just referred the board to, which itself was a recantation case, in which the court rejected a recantation as being patently false, Justice of Appeal Rosenberg in Babinski explained that the admissibility on appeal of the recantation required an assessment of the credibility of that recantation, even if it's being offered simply to impeach the contrary evidence at trial. And we see that from paragraphs 51 to 52 of Babinski. So paragraph 51, starting on 27.
So, 3933, I think.
Giving you
3933.
I'm grateful, my lord. It's because Babinski is actually attached to. Yes, I'm grateful. It's attached to Muller and Friends' reply. I'm grateful. Yes, starting on 3933, and then through to 3934, 3935. So, in addressing the recantation of the witness, at paragraph 53 in particular, Justice of Appeal Rosenberg, and I would just emphasise, perhaps in that paragraph, the last sentence. In those circumstances, the bare recantation is so lacking in credibility that even as impeaching evidence, it lacks sufficient forensic value to overturn a conviction otherwise free of error. And then we see the conclusion of paragraph 70, which is 3940. Reasons provided by L to support his claim that the recantation is false can be demonstrated by credible evidence to be untrue, fresh evidence reasonably capable of belief, even if particular statements by L, since the trial cannot ultimately be demonstrated to be credible. And we say the analysis that one sees there in Babinski was applied in a case that Muller and Friend relies on, which is the case of Snyder, which the board has at 3672. And that's one of the, if I can call them this, the quintet of cases that Muller and Friend cites in his written case. And we say that there's nothing said in Snyder that is at odds with Babinski. In other words, a credibility assessment is still required even if the recantation evidence is relied on simply for its impeachment value. And we take that from paragraph 54 of Snyder, which is page 3690. And I mean, the rationale for requiring recantation evidence to satisfy a minimum threshold of credibility is fairly self-evident in my submission, even when it's being offered for impeachment value. And just to refer to another Canadian case, it's the case of MGT that sets out really the rationale behind it. That starts at 3329, but it's really for this purpose of this submission. It's what is said at paragraph 104, which is at 3343. Credibility being evaluated not with a view to determine ultimate reliability, credibility, but in the context of determining whether the evidence is sufficiently reliable, credible to warrant admission on appeal. And then what is said over the page, paragraphs 110 to 111, must assess the credibility of the recantation and then set out the relevant factors to consider. And we submit, and we've cite that particular paragraph in our written case, because we submit that's a logical position. Admitting a recantation without regard to credibility simply because it was made would not serve the interests of justice. It would permit any witness, by simply repudiating or changing his trial evidence, to reopen trials at will to the general detriment of the administration of justice. And that's not a point that's just being made by the Canadian courts, that's made by the Court of Appeal of Trinidad in the Moon Sami case, which we cite in our case. It's at 3351 is the Court of Appeal judgment of Trinidad in Moon Sami. And it's, for this point, it's simply paragraph 12, page 3355, where the Court of Appeal says it is not simply a conduit through which proposed additional evidence is uncritically advanced. The evidence must satisfy a minimum threshold standard of credibility and reliability in order to justify its reception. Otherwise, there would be no proper end to the adjudicative process. And we say when you draw all those threads together, and then one has to apply this in practice as an appeal court faced with recantation evidence, it's for all those reasons that it is extremely important that the court, when assessing the credibility of recantation evidence, examines the explanation that's being offered for the recantation. And as I said previously, the extent to which it's supported by either the trial evidence or other evidence offered on appeal. And we say that that is what the Court of Appeal said that they would do and then went on to do. And it's a point that's made in this jurisdiction as well in the well-known case of R and Flower. And I would invite the board to have this. It's 2878. And it's the judgment of Mr. Justice Widgery, as he was, at 2882 D, and then over the page to A, perhaps with particular emphasis of what is said at G. If the witness's new version of the case is disbelieved, this may very well show he is now unreliable, but it is a fallacy to assume from this that he was also unreliable at trial. Witnesses may have second thoughts for a variety of different reasons. And then, as I say, over the page, and we cite that particular paragraph in our written case. And finally, on sort of legal principle, and on this point, it's a point that's made in the case of CASA, which is another decision of the Ontario Court of Appeal that I would invite the board to have regard to. It's at page 3178. We set it out and deal with it in our written case, but the relevant passage is starting at para 94 at 3207 through to and including 97, particularly at 97, where Justice of Appeal Laskin is referring to the rigorous assessment of fresh evidence. And the overriding standard being in the interests of justice, which requires the court to consider how the recantation came about, and more particularly, whether the appellants played any role in producing the recantation. And it's a point that we make at paragraph 46E of our written case by reference to CASA. And it's probably easier just to take it from our written case at 2632. That there were extensive communications in CASA between the appellant and the recanting witness while the appellant was incarcerated. And the recanting witness only changed the story after she had established contact with the appellant, and the appellant had made a number of promises to the recanting witness and had influence over her. And at paragraph 136 of the judgment, the Court of Appeal found that the recantation was the product of collaboration, or at least a product of the appellant's influence, and was therefore not in the interests of justice to admit it. And we do say CASA repays reading, because the Court of Appeal in the present case appear to have applied analogous reasoning in concluding that Grandison's recantation was too heavily tainted by the appellant's influence to be in the interests of justice to admit it. That being one of the key findings that they made, albeit not the only one. I can, for present purposes, until we deal specifically with ground one, perhaps just put the authorities to one side, and I want to just now deal with the Court of Appeal judgment, which I can take fairly swiftly because we have set out our analysis of it at paragraphs 25 to 41 of our written case, which is page 2619. And we make the point there, and I made it in opening, that when one looks at paragraph 102 of the Court of Appeal's judgment, we say that is the correct test set out there. That's 1129 of the bundle. And that's read with paragraph 105, where the Court of Appeal states the possibility of coercion in the production of the statutory declaration is a material issue, which the court must take into account in assessing credibility. Again, we say the Court of Appeal clearly directing themselves correctly. And what then follows is a detailed critique of and analysis of the fresh evidence, focusing on really three aspects: Grandison's recantation as contained in the statutory declaration, the audio recordings, which were relied on by the appellants to support the recantation, and then the retraction of the recantation through the evidence of David Ned and the statement that was attached to his affidavit. If I can just deal with those three aspects of the fresh evidence, and perhaps deal first with the audio recordings. Again, I'll probably tomorrow come back to this when dealing specifically with ground three, which is the full frontal attack that my learned friend makes on the Court of Appeal's analysis of the audio recordings. But you see the Court of Appeal dealing with them at paragraphs 121 to 151 of their judgment. And what we've sought to do at paragraphs 30 to 37 of our written case is provide a summary and analysis of the Court of Appeal's consideration of those audio recordings, which needs to be read with Appendix 1. And as I outlined in opening, the purpose of the analysis at Appendix 1 is really designed to show that the findings made by the Court of Appeal, having listened to the recordings, read the transcripts and heard from Mr. Maharaj, clearly withstand scrutiny. And the appellants clearly come nowhere near satisfying the board. These were perverse findings made by the Court of Appeal, which is the test they have to satisfy. And you see the Court of Appeal's conclusions in respect to the audio recordings at paragraphs 150 to 151. And we say the Court of Appeal was plainly entitled to reach those conclusions. And perhaps just by way of example, and it's difficult because just as my learned friend sort of took you to excerpts of the 18 or 19 so transcripts and phone calls, they do all need to be read fully, and they need to be read in context, because it is very easy to make points, perhaps not deliberately, but make points when things are read out of context. But if I can just ask the board to have a look at the first transcript, and the reason the first transcript is arguably a good starting point, is it is the only conversation that takes place prior to the recantation. Although it's not dated, I think it is, Grandison refers to it being in April 2011, and Maharaj gives evidence that it's April 2011, and there's no reason to doubt that they're wrong about this. So it takes place a couple of months before the recantation. The transcript is at 985. And the first appellant, Maharaj, repeatedly asks whether Grandison is understanding what he's telling him. And these are all points that are made in writing in our Appendix 1, and so perhaps I could leave it there, but perhaps just make a few brief points, because the Court of Appeal notes that at paragraph 130 of their judgment, and they make the not unfair point in my submission that Maharaj is preoccupied that Grandison's evidence on appeal appears truthful. And then there's the reference to mash up the state that is at 989, which the Court of Appeal, again, I say not unfairly, interpreted as Maharaj inviting Grandison to give testimony that would undermine the prosecution case. And there is also the point that's been made and is not answered by Mr. Maharaj. Yes, he might not have been able to record all conversations between himself and Mr. Grandison because of issues with his mobile phone, although the part of the transcript in his evidence in the Court of Appeal is not that clear. But it doesn't explain why a number of these calls start I say halfway through. We don't know if it's halfway through. We don't know if it's near the end, but they certainly do not start at the beginning. And this is a good example of that. And it is a curiosity, and it's something else that the Court of Appeal were entitled, in my submission, to take into account when assessing the effect of the audio recordings on the credibility of the recantation. And I do say that this first conversation needs to be viewed alongside the text messages that Grandison stated that he received from the appellants, because the text messages start in April 2011 at around the same time as this call. And they're set out in his retraction statement at 959. And the learned friend referred you to the retraction statement, referred you, though, to the last text message that is sent that refers to Bless. But I would invite the board to have a look at 959 and the text about just a bit above halfway down the page on 959, where, and I think if we had a color copy, this would be in red, because Officer Ned explains that the texts are set out in red and the rest of the text is in black. But you see 27/4/11, 10:14 p.m. Tell them that Don told you that Nigel Rajkumar evidence did not stand up because he confessed 3 murders and the police charged different people for one of them. So there, and then you know his evidence could not stand up. So he told you that you needed someone else and you accepted their offer. So, and then 18/4/11, about 5 lines down, all the text I sent you, write them down on paper, delete all the messages from your phone. Now, Grandison, we know, didn't follow that instruction. He handed the mobile with all of those texts to David Ned. It is unfortunate. It would appear from what David Ned tells us, he handed the mobile to Senior Superintendent Kuhn. We see this from paragraph 8 of his affidavit at 1196. And it would appear that it has been lost, because as I think I interrupted my learned friend just to draw attention to Frederick's second affidavit. The state were not able to ascertain those texts sort of independently through Digicel, or despite trying, because Digitel told us that they didn't keep the text messages. But the point the Court of Appeal make is that this part of the retraction statement is corroborated by Maharaj's testimony that he paid for and had a cell phone and SIM cards to Grandison. And far from supporting the fresh evidence application, the audio recordings in my submission demonstrate precisely why it was not in the interest of justice to receive Grandison's recantation, because it was the product of the appellant's influence. And as I say, I'll return because there's much that can be said about them, and a lot has been said in writing. And I would invite the board to read Appendix 1 of our written case, but I'll return to it insofar as necessary when addressing ground 3 tomorrow. But leave the audio recordings there for the time being. The next piece of fresh evidence is David Ned's affidavit. The board have that at 1195 to 1197. And you have Grandison's signed statement, which we've just been looking at 957 to 960. And you've also got the statement that Grandison provided to John Frederick on the 8th of August 2013 at 922 to 924, albeit the Court of Appeal attached very little, if any, weight to that because it was an unsigned statement. So the focus is on David Ned's affidavit and the signed statement of the 15th of July, which I'm calling the retraction statement. And we've provided a summary of that retraction statement in Appendix 2 of our written case. And for the reasons we set out at paragraph 39, which is 2626, we submit that the Court of Appeal were plainly entitled to find that Ned's evidence that Grandison admitted to him that the appellants had coerced him into recanting his trial evidence satisfied the necessary credibility threshold. And that's important in my submission in a number of respects, because most notably, it provides a coherent explanation as to how and why the statutory declaration came to be made. And as I say, we've set out to paragraph 39 of our written case various points, and I just make them briefly so the board has them. There was no challenge to Ned's evidence, which the Court of Appeal found to be cogent, credible recollection of events between himself and Grandison. Ned's evidence was in part corroborated by Maharaj's evidence, and we've seen that about the mobile phones. Ned's evidence explained the timing of the recantation, and it also resolved a number of peculiarities regarding the recantation. For example, why the deceased's brother would seek to convict the wrong people for his brother's murder, which is explained in the retraction. The third piece of fresh evidence is obviously Grandison's recantation itself. And we have summarised at paragraph 40 of our case, 2628 through to 2630, the reasons why the Court of Appeal could not test the reasons why the Court of Appeal concluded that the recantation contained in the statutory declaration was not capable of belief. And there are, I'm not going to repeat what we've set out in writing, but you can reduce it really in my submission to 4 main factors. First, the fact that Grandison was not present, and so the court could not test the credibility of his 2 contradictory accounts. And the Court of Appeal judgment, where it explains its reasoning there, is paragraph 170 of its judgment. The second factor is that the timing and circumstances in which the statutory declaration was made were, in my submission, on any view, suspicious and called for an explanation. Now, the board will, I'm sure, have the timings well in mind, but we know that Grandison says he had been saved and turned to Christianity in 1998. He knew, if his recantation is to be believed, as far back as 2001, that his trial testimony was false. Now, he could have informed the police or prison officers he was in contact with at that stage, could have stopped the trial or preliminary inquiry, could have sought protection. We know he was released from custody in November 2001. The reference to that is 950. and that he was in state witness protection program until I think until 2010. The recantation was not made until some 10 years after the trial. Now, even if he was fearful of the police, and I'll come back to that when looking at the audio recordings tomorrow, but even if he was fearful of the police, which we say there's no corroborating evidence that he was, and in fact his behaviour suggested he was quite comfortable with the authorities, given his approaches to Officer Ned. There's still no explanation provided for the delay of almost 1 year after he left the witness protection programme in 2010 before the recording of the recantation. And the reason the timing of the recantation is suspicious is because it's only after contact is made with the appellants that he produces the statutory declaration recanting his trial testimony. And as the Court of Appeal conclude, this is paragraphs 154 to 155 of their judgment, they say the only plausible explanation for the timing was that it was the first appellant, Mr. Maharaj's idea. Now, the third of what I say the four main factors when looking at the recantation is the repudiatory statement or retracting statement he gives to David Ned, which, as I said a moment ago, explains a number of odd aspects of the recantation. And just what I mean by odd aspects is perhaps give a few examples. The most notable is the lack of any evidence in the recantation to substantiate why Grandison had falsely incriminated the appellants. Now, my learned friend referred extensively to sort of a grudge, but that relies on a particular reading of one of the audio transcripts that I say can't be interpreted in the way my learned friend, or certainly the Court of Appeal were entitled to interpret it contrary to how my learned friend interprets it. But there's no substantive explanation as to why he has given evidence against the appellants, who, I think I'm right in saying, there was Mr. Maharaj said his evidence was he didn't know Grandison in 2011. And as the Court of Appeal sort of noted paragraph 158 of their judgment, and this is a point I've made already, so perhaps can make it very quickly. It's the point that if it is to be believed that the court would have to accept that he had participated in this alleged fabrication, having memorised a detailed account, and then 2 weeks later given that account again in the preliminary inquiry and again over 3 days of cross-examination and trial, all the while holding these conscientious and religious beliefs that he said he held since 1998 when he turned to Christianity. And the board obviously has my submissions on the trial evidence. There was also no logical link between the alleged police orchestrated execution of his girlfriend and his false testimony against the appellants. And this is a point that the Court of Appeal note at paragraph 159 of their judgment, page 1150. And there's also the point that the recantation also relies on the deceased brother seeking to convict the wrong people. Now, this is someone who, Grandison was someone who was a complete stranger to him. And the suggestion is that it was to gain retribution for some alleged prior ill treatment that Grandison had suffered at the hands of the appellants. Well, again, it doesn't withstand any form of scrutiny in my submission. And the fourth factor that obviously heavily featured in the Court of Appeal's assessment of the recantation was the audio recordings, which I've already touched upon. But they made the finding that they showed evidence of coaching, prompting, and influence. That's paragraph 172 of their judgment. So when you take everything into account, I submitted that it is entirely unsurprising that the Court of Appeal concluded that it would not be in the interest of justice to receive the fresh evidence. I move now to ground one. I mean, the short answer. Sorry, my lady. My lady, I'm sorry, I can't hear you.
Sorry. Did you say that Grandison was cross-examined at trial about a bribe offered by the brother of the deceased?
He was crossing. I would need to check whether it's about a bribe. He was cross-examined. Let me give you the reference. He was I'll find the reference to the cross-examination, but it's in the summing up at 591 line 49. He was the fact he told Vern Pierre that he had been given an inducement to testify against the appellants by the deceased brother. And I think I could probably find the.
I'm quite happy for you to send that through in due course, but there was previous cross-examination about this.
Yes, I mean for the judge to put that in summing up, it must have been, and I'll find you the reference for that.
Yes, and therefore going to the exhibit to Ned's statement, this is the retraction of the recantation. We see that 27th April 2011, 10:14 p.m. there's reference to tell them Don told you that Nigel Rajkumar evidence did not stand up.
Yes.
So it will be perhaps interesting to see what he was actually cross-examined about.
Well, he was also separately cross-examined about that, because I think the theory, or certainly the theory from one or more of the appellants, was to suggest to Grandison at trial that really he was patching up the prosecution's case, and that Rajkumar, having been discredited, he was parachuted in to then provide the evidence he was doing. But then separately, it was put to him, perhaps a part of the same theory, but it was separately put to him that he was also giving evidence because he'd been given an inducement by the deceased's brother.
When you find those references, could you get them to us?
My lady, of course. I probably could do it now in 30 seconds, but it's probably more use of time if I just give you them first thing tomorrow morning.
Yes, of course.
The short answer to the complaints made under ground one in my submission is that the Court of Appeal was correct to ask itself whether the fresh evidence was capable of belief. And as I've said previously, even if it was simply being relied on as for its impeachment value rather than the truth of its contents. But I do say it is worth bearing in mind that the appellant's position before the Court of Appeal was that Grandison's recantation was plainly capable of belief, and we can see that from the submissions that were made to the Court of Appeal, and it's referred to in the Court of Appeal's judgment at paragraph 77 of their judgment at 1120. So it was relied on both as substantive evidence undermining the conviction and for its impeachment value. And I'll perhaps just give you a reference in.
Right, to be clear, so the distinction you're making is by substantive evidence, you mean as evidence of the fact that what he said at trial had not been true?
My lady, yes.
As opposed to impeachment evidence, well, you just can't believe a word he says, so he's so unreliable, the jury wouldn't have convicted.
Well, it's really, the distinction is yes. I think the answer is yes, but the distinction I make in my mind is evidence of the truth of what is being said, as opposed to evidence of the fact it was made. Because I think it is said, Mr. Fitzgerald would say, the fact that he has made an inconsistent statement can be relied on to impeach his evidence by simply pointing to the fact that he said something, one thing at one point in time and a different thing at another point in time. That's really what I mean by for its impeachment value. But both horses were being ridden by the appellants, and the appellants expressly invited the Court of Appeal to determine the question of capability of belief. And again, just let me give you some references. 1228, lines 7 to 12. These are transcript references from the Court of Appeal. 1129, lines 34 to 46, where it said the retraction plainly capable of belief and is admissible. And then 1241, lines 29 to 48, same point being made. So I say you can't really criticize the Court of Appeal for making a determination that was expressly invited to make. But as to the contention that I had thought was being made in my learned friend's written case, which is that the Court of Appeal ought to have received the fresh evidence regardless of its credibility. Well, the board already has our submission in response to that, which is when dealing with the legal principles, I say that would have been wrong in principle and dangerously wrong in principle. And we make 3 points in our written case. It's paragraphs 48 to 55, page 2633. And I will, if I may, just expand, well, perhaps not expand, but try and summarize what we say there. I mean, firstly, we say that the appellants haven't identified a single reported case in which the fact that a recantation statement has been made is of itself and without more sufficient to justify its reception as fresh evidence on appeal. And that's for what I call the first of my 4 principles, that recantation evidence is easily fabricated, and the reasonably capable of belief test is an important safeguard against that risk. And that's the point that was graphically made by the Court of Appeal in this jurisdiction in Asif Patel. We've sent that out of paragraph 50 to 52 of our written case, but perhaps invite the board just to have a look at that case itself. It's 3393. And probably take paragraph 1 as looking at what this was all about. Effectively, the Court of Appeal was invited to receive fresh evidence consisting of affidavits that were sworn by a key prosecution witness that was referred to as YA, saying that he had given false evidence at trial and had been promised assistance in obtaining leave to remain in the UK in return for giving evidence for the prosecution. Now, the unusual feature of Patel is that none of those affidavits were relied on by the appellants as being true, but rather just to show that YA was inherently unreliable. And the Court of Appeal was invited to reach that conclusion on the documents alone. And Lord Justice Leveson, as he then was, rejected that submission. And if I invite the board to look at paragraph 38, 3404, and it's really the passage at the top of the next page, 3405. And it's the last 4, in particular, the last 4 lines of paragraph 38, where he takes the entirely hypothetical situation to illustrate the position, where it's not difficult to visualize circumstances in which a witness makes a second statement, undoubtedly contradicts his first, but does so at gunpoint. The fact of the inconsistency is not of itself sufficient. And we say that what the Court of Appeal is saying in Asif Patel really underscores the importance of fresh evidence needing to satisfy a minimum threshold of credibility. And the second point of our 3 points that we make in our case, and it's fairly closely related to the first, is we say that the appellant's arguments amount to saying that despite the Court of Appeal finding Grandison's recantation was not capable of belief, it ought still to have been admitted as fresh evidence because of its impeachment value. Now, first we say obviously not the correct approach, because otherwise you'd have all recantations would be admitted automatically as fresh evidence. But the fact that that is not the approach is because of all the concerns that have been noted in the recantation cases that I've taken the board to, and you can see it in the Palmer case. We set that out at paragraph 53 of our case at 2636. and I think we quote the relevant passage, but the relevant passage is at 3380, which is Palmer itself, where it says it would not serve the interest of justice to permit any witness by simply repudiating or changing his trial testimony to reopen trials at the will to the general detriment of the administration of justice, which I think is probably the point I've already made. And you have the case of the Queen and Flower, and Mr. Justice Widgery's judgment that we set out for this proposition at paragraph 54 of our written case. The third point we make is that what I call the sort of quintet of cases that my learned friend relies on, or certainly relied on in his written case, to support this proposition that fresh evidence should be admitted irrespective of whether it's capable of belief or not. We say that those 5 cases do not support that submission, and we deal with them at some length, and I don't propose to do so orally, but if I just give you the references in our written case, it's paragraphs 56 to 88. And perhaps well, my lord, my Lord James, I'm in your hands. I was going to say I can finish this point, but probably not less than 10 minutes. Sorry, I can't hear you, my lord.
I'm sorry, I'm muted. If we're going to take that long on it, I think probably better to look at it in the morning.
My lord.
How are you doing? How are you doing for time?
I was going to say, for what it's worth, I'm ahead of my timeline.
Right. Well, we'll look at it at 10:30 tomorrow morning, Mr. Poole, if that suits.
Thank you, my lord.
Grateful to you and to Mr. Fitzgerald, and we'll resume tomorrow morning at 10:30, please. Court's now adjourned. Thank you very much.